Good afternoon and welcome to this week's presentation of a webinar by Beresford Booth. My name is Oscarsson. I'm a member of the Estate Planning and Probate group here at the firm, and I'm joined by Sarah Smith also in that group. And our topic today is planning considerations for your surviving spouse. This is not going to be an exhaustive discussion, but just some of the things that go into considering how you do your estate planning, and particularly with respect to a surviving spouse, and some of those things that you may want to consider. You may feel that there's no need to consider some of these things, but we just wanted to kind of give you kind of a little outline of those things. One of the things that we normally think of, I think most people might think of, is I'm going to give everything to my surviving spouse. That could be because maybe there's not a huge, and I'll leave open what huge actually means as far as an estate, because I think there are different definitions depending upon who you're talking to. But if you have a smaller estate, let's say under $500,000, just to pick a number, and maybe it's all community property. Well, in making a will, you can only give up to your 1/2 of community property. You can't do anything beyond that. And so typically what I've seen has been that each spouse gives everything to their surviving spouse, but then also provides for contingent beneficiaries in the event there is no contingent or there is no surviving spouse. It's relatively easy to do it that way, but there are some other things that you probably want to consider. And maybe I'll throw that to Sarah for a couple of those things, and we can chat about them. Sarah?
So as you pointed out, leaving gifts, it's an outright gift to a person is typically what fits for a lot of people. It's the easiest thing for us to draft. It's the easiest thing for the survivors to administer and to deal with. Here you go, in your pocket. I trust you to make good decisions. And all of that simplicity is very good, again, for many people, but there are certain considerations that you might want to think about. For example, is this somebody with whom you want to give a no strings attached gift? In your pocket, go forward and make good decisions. Are they going to be able to make good decisions? I'm not going to lie. I have had many a conversation with my husband about how many shoes I have. He's of the opinion that you don't need more than 3, maybe 5. I'm of the opinion that you should add a 0 to the end of that. He might have concerns about how much I'm going to spend on shoes if I've got him looking over my shoulder. I say this as a joke, but in practice, there really are situations where you may not want someone to have unrestricted access. There might be financial considerations. Somebody might be a business owner and you're trying to protect against the liability from that debt, or in a high-risk profession where you're trying to protect against the possibility of a malpractice suit, God forbid, or some other significant financial liability from them conducting their regular course of business. There may be remarriage concerns. Perhaps this is a blended family, and you're concerned about protecting where those assets end up to, there's your kids, their kids, our kids. How do we make sure that everybody is taken care of in the ultimate disposition after both spouses have died? Do we see everybody as the shared children and we trust that the surviving spouse will take care of everybody? Or do we want to create a structure where we can control what happens with whatever funds might be left over? Not taking away from the surviving spouse's livelihood during their lifetime, right? We can still set up a trust that takes care of them during their lives so that they're comfortable and safe and happy, but making sure at the end of that all of the children are taken care of, or perhaps that some money goes to charity, even though one partner thinks that it's important and the other partner may have a different opinion. The benefit of the trusts, the benefit of gifting outright is clear and straightforward. It is simple, it is easy, it's very efficient. except when it isn't. It's not always about the financial considerations. There can be interpersonal considerations to think about. And from the financial perspective, an outright gift, when we're talking about a $500,000 estate, that I'm not worried about the tax liability there from the estate, a tax perspective. Federal estate tax exemption presently is just over $12 million. You're fine. Washington State, we're at $2.12 million. You're still fine. But if you have a larger estate where we're going to be going north of that number, and you leave an outright gift to the surviving spouse, Pear, as you know, we have what we call the marital deduction. It's really more of a marital deferral, where the surviving spouse doesn't have, the estate doesn't have to pay estate tax on the amount that goes to the surviving spouse. The idea being that we're just going to kick that down the road. We're going to give the funds to the surviving spouse. We want to make sure that they're taken care of, right? But they're going to go and tax it later when the second spouse dies. Government's still going to get their money. They're going to put it off for a little bit. That's wonderful. But it does mean that when you leave an outright gift, you're increasing the size of their own estate. So what might have been an untaxable estate, $500,000, $1 million, they receive your $1 million, have a little bit of growth. Suddenly there's a $2.5 million estate. Might be estate taxes then. And that might not be the best outcome. At 2.5, maybe we say we make some gifts, not a problem. Make a couple of gifts. But if you're at 5 million, 10 million and going up, maybe gifting alone isn't the solution. Maybe then we want to look into not just estate planning, but specifically tax planning and the kind of options and strategies that are only available in things like trusts.
Right. Another thing that I think of too is maybe not so much the financial ability of the surviving spouse, but maybe unfortunately the surviving spouse has maybe started to suffer some dementia and is deteriorating mentally. Physically, maybe absolutely fine, but depending upon how quickly that happens, it may be appropriate. Although you may not like it, but it may be appropriate to be providing a trust for the benefit of the surviving spouse, because of the fear that if you don't make a change to the will at some point, and whether that deterioration in mental capacity is sudden or over long term, providing a trust, which may or may not have any tax benefits to it at all, but it provides for someone to serve as a trustee who has the ability to manage the trust and distribute cash or other assets as needed by the surviving spouse. So that could be, I think, another potentially significant consideration. But I think that consideration also applies to a number of other people who might be included in the will. They may not be ones that you think either could not handle financially what they're going to receive, or they may not have the ability, the mental ability for whatever reason. Traumatic brain injury is another one. That brings up a whole different kind of trust, like a special needs trust, which potentially could be one for the benefit of the surviving spouse as well.
Absolutely. If a surviving spouse is on some government benefits, the restrictions on those are quite significant. A trust can be a way to try and protect that being disrupted.
Right.
If we're looking at trusts, the reality is trusts are going to be more expensive to establish. They're going to require more administration, tax returns and accounting and all of those things. But they do provide a lot of this flexible planning, whether it's tax planning, ensuring that people are put in trust, are put in a position to manage the assets for the benefit of the spouse and protection of future beneficiaries. I mentioned earlier blended families and remarriage restrictions. Very often the surviving spouse is the trustee of their trust for their benefit, but maybe we don't make that trustee the surviving spouse, or the surviving spouse is only the co-trustee. So we're adding that outside oversight, that outside responsibility, shall we say.
Right. Which may or may not be an individual. It could be a professional trustee. That tends to be more expensive because they typically will charge a fee, and those fees vary. An individual, very often, I think, if they are a good friend or another relative in the family, will very often not charge any kind of fee whatsoever. That, of course, could change over time, depending on how much time they're being required to devote to administration of the trust. And initially, they may be willing to do that without any charge, but those circumstances may change. And I think also with the trusts, particularly trusts that are established in a will, you can have the trusts that are set up that they basically are automatic. They come into effect upon the death of the maker of the will. But you can also have trusts that are provided for in the will, but they are optional to be used by the surviving spouse. For example, I've seen several times where the surviving spouse would have the right to disclaim an interest in the deceased spouse's property. And the deceased spouse in their will provided that, well, if my spouse does that, then the property will go into what's known as a disclaimer trust, still for the deceased or still for the surviving spouse's benefit during their lifetime. But it also has the benefit that when the surviving spouse dies, whatever is left in the trust is not considered part of their estate for purposes of determining whether they have an estate tax obligation or their estate has an estate tax obligation. And the requirement for something like that is that the deceased spouse in their will, when they provide for a disclaimer trust, provides for what happens to the property upon the death of my surviving spouse, because the surviving spouse cannot control it. So those are a couple of things that you can think about as far as what kind of trusts, whether they be for tax purposes, non-tax purposes, and whether they be something that is automatically created upon death of the deceased spouse, or is something that the surviving spouse has the option to use, because the circumstances at the time that the will is created and signed may be significantly different, whether in a positive way or a negative way, than the circumstances that exist upon the death of the first spouse to die. One would hope that the financial situation, whatever it is, of the spouses at the time that the will is signed, increases over time. But I have also seen where there was a lot of planning done maybe many years ago when some of these tax thresholds were significantly lower, and it made a great deal of sense to plan in a particular way. Now, with increases both in the federal and the state tax thresholds, that may not make as much sense and may provide more of a loss of control for the surviving spouse over the assets than would have been appropriate if those tax thresholds had stayed about where they were at the time that the will was signed.
You're right. Disclaimer trusts, the disclaimer feature in those types of marital trusts can be a really great option for providing flexibility. Obviously it is our hope that even if you're not updating your estate plan every few years, that you are reading and reviewing your documents every few years and making sure that it still says what you want it to say, that it still fits your situation. If you aren't, this is a great time to build a good habit. Disclaimer trust, as you know, that disclaimer option has to occur within 9 months of the date of death of the decedent. So something you might think about is, do you have, the individual in question, whoever the surviving spouse might be, are they going to be organized and follow up and be able to comply with that 9-month deadline? Or is that going to be too stressful or, too something that would be too easily missed? And then perhaps, even if we're having a reduction of flexibility, that mandatory aspect of the trust may still be more prudent to protect some of that tax planning, even if it doesn't fit quite perfectly or as perfectly as we might otherwise be able to do with the disclaimer function.
Right.
If it's going to be too stressful for the surviving spouse to have that conversation within X number of months after the decedent's passing, maybe they just want to not deal with it. So there's a lot of things that we can do as estate planning attorneys and as creative drafters. But what's really helpful is for, the clients, for the people who come in, to have a thought and an understanding about the practicality, the personal decisions and the personal goals and preferences. What are you concerned about? What are you hoping for? What would you like this plan to do if I can wave my wand and make it look and do everything that you want it to do? And then we as attorneys can more effectively find the options that fit those goals.
Right.
Right. It's a collaboration.
I'm sorry.
It's a collaboration really between us and the audience, the clients.
Right. I think it also kind of leads us into another aspect of the estate planning that it's related to the distribution of property, but it has to do with who's going to be in charge of doing it, whether it's be a trustee or whether it be the personal representative of the estate. Mm-hmm. Very often I have seen that the personal representative of the estate is the surviving spouse. Mm-hmm. But I have also seen, not as frequently, where the surviving spouse will decline to serve. They may not have much experience in having dealt with the financial situation of the couple. Maybe the deceased spouse was, quote unquote, in charge of the checkbook, or in charge of the investments, or in charge of making sure the property taxes and the insurance on the real estate and the vehicles, if any, got paid. And the surviving spouse is now kind of thrust into that role as a personal representative and may feel very uncomfortable in that role. So whether it be a trustee, even if they served as a co-trustee on an existing trust, they may not have actually done a great deal and relied on the other spouse. Mm-hmm. But I think it's always good to have, particularly with wills, nominate your primary personal representative. They have the ability to decline, whether it says so in the will or not. Right. And if they do, hopefully there is at least one alternate that's been nominated in the will who could either step in before a probate is even started. And that would be the person who would then submit the petition to open the probate to the court, and they would then be appointed as the personal representative. That doesn't mean that the surviving spouse is no longer involved, because I've seen it several times where the alternate is one of the children of the couple. And that child, whether they're an only child or whether they're one of several, well, particularly if they're one of several, they will talk with the surviving spouse about what would you like to do, and I'll take care of it. But ultimately, that child may be the one who is responsible because they have been appointed as the personal representative. But it takes a great deal of the potential stress, and I don't want to just say stress because I think for some personal representatives, it is not particularly stressful. There are some things that with guidance of an attorney you can get through. It is possible to do a probate without having attorney involvement. I think if you don't have attorney involvement, that could be stressful, because understanding exactly what your responsibilities are, how to get it started, what needs to be done, it can be stressful trying to find that out.
Mhm.
An experienced estate planning and probate attorney can help with that quite a bit. And so I think having someone to assist the personal representative from a legal standpoint is very beneficial. And I think it can help reduce the stress for everyone involved.
Absolutely. And not even necessarily, when we're thinking about these kinds of roles, like the personal representative and the trustee, it's also good to think about not just the so-called testamentary documents, but also the living documents,
Right.
the durable financial power of attorney, the durable healthcare power of attorney. When we're thinking about taking care of that surviving spouse, we also want to think about agents who would be able to assist them during their lifetime. Let's say one of the partners was the one who handled all the finances. Do we have one or more persons indicated in the durable financial power of attorney who can step in and help, mom or dad with the continuation of their financial lives, not taking away authority, right, but coming in to assist? Right. Especially, as you were saying earlier, in the event that that surviving spouse were to develop dementia or some other illness or injury that prevents them from making decisions and taking actions on their own behalf.
Right.
And who would that child be, or that friend, or even if necessary, that corporate fiduciary? True.
And I have, particularly with powers of attorney, I have seen quite a variety of who is appointed. Because sometimes, because one of the spouses may be suffering a little bit of cognitive decline, mm-hmm. the other spouse names maybe a child, but even with children, they may appoint a very good friend of theirs as their attorney, in fact, because number one, they know their spouse is unable to do it, or is very likely to be unable to do it. Mm-hmm. And sometimes, unfortunately, particularly when there are multiple children, and I'm saying multiple children all being adults, that when one of them is put into a position, whether it be as the attorney in fact under a power of attorney, and I would think primarily for financial purposes, for my point, or as trustee of a trust or personal representative of an estate, they get put in a potentially difficult position because of their siblings. Their siblings may, not always, certainly not always, but may, I also hate to say, they may shoot the messenger. Particularly on something with a will. You've got a will that's very clear. It says this is how the property should be distributed, and somebody gets mad, right? Because somebody is getting more than I think they should, or I'm not getting as much as I think I should, and I'm going to get mad, and I'm going to take it out on the personal representative, which is why I say shoot the messenger, because the personal representative, the child, usually, at least in my experience, has not had anything to do with the creation of the will, and may not even know what the will provided until their parent died. Mm-hmm. And they may not even have known that they were nominated as the personal representative.
So that's a really good point, is thinking about and discussing with us, what are the family dynamics? What are the relationship with the kids, with the, whoever the surviving spouse might be, with the parents? Is it possible that we need to be sensitive in drafting to avoid any kind of backlash to that surviving spouse from children or other family members, or try to get ahead of it in some way if somebody might be prone to being litigious, or at least being of the shoot the messenger mindset.
Being difficult.
Being difficult, exactly.
However that looks.
Precisely.
Yeah.
You know, and the more that you can communicate with us and tell us, the more helpful that we can be on that front as well.
Right. So it is definitely a collaborative process between the attorney and the estate planning client or clients. With any luck, their interests are aligned.
Yes.
May not be entirely, but usually that is not really a problem. But it's definitely something that I think clients need to keep in mind when they are considering the planning. And I think considering the planning, the earlier the better. I think that the most difficult thing with estate planning for a lot of people is just getting started, because to get started on your will, you have to contemplate that at some point you're going to die.
True.
And from my understanding of math, there is a 100% chance that you will die. I think
And
most
taxes,
people
right?
postpone that as long as possible, but it is going to happen. So if I could leave our audience with anything, I would say start the process if you haven't already. And if you have estate planning already done, take a look at it periodically. Periodically being every year, every couple of years, or if you've even recently done any or recently had your estate planning done, but there has been some significant family event, whether it be just between the couple, like additions of property or deletions, eliminations of property, or there have been additions to the family that you would like to make sure that there's provision made for a new member, whether it be an infant that is now in the family, or an adopted child. Stepchildren, they can certainly be included in wills. Understand that if there is no will and you have stepchildren, they will not inherit. But when you have a will, they can.
And don't just rely on the will. For
Right.
most people these days, at least, there are going to be things that property that transfers outside the will, so-called non-probate assets. These might be qualified retirement accounts, life insurance, annuities, things of this nature. You're going to want to make sure that your beneficiary designations on those accounts are up to date. And I would suggest, when you're looking at your estate plan, look at those beneficiary designations at the same time, because
Right.
if these have conflicting provisions, generally speaking, the contract is going to win. So whatever agreement you have with blank life insurance company, that's who they're going to pay to upon your death, even if your will says something else.
Right.
And generally speaking, you don't want those just blanket going to your estate. You do want them going to surviving spouse or whomever you may choose to leave those things to. And that should also be part of the conversation with your attorney, making sure that everything lines up and works together seamlessly.
Right. Well, I think with that, I'd like to thank everyone for joining us today. Next week, our family law group and assisted reproductive technology group will be presenting a webinar on Thursday. Please join them then. Thank you.
Thank you.